up? Hey, you digging me? Hey, Sierra. Hi, everybody. You know it. You know it. You digging me? You heard it first. I'm waiting for some people to get on in here as we go over some updates. I have not seen you guys in a while. Welcome back. I haven't done any coverage of Young Thug for a while because the other people were playing it on their lives. So I didn't feel like I needed to play it, play the stuff that was played and all that. So I said I'm gonna give you guys what's not on the news. Hey Candy, hey Steph, hey Demetra, hey Miss QP, no QTPI pie. I don't know what I'm saying, but good afternoon, everybody. Good afternoon. So, one of the reasons why I was like, I'm not gonna spin the wheel because they're already showing it. So why should I show it? But you know what? The things that I'm gonna share with you is the things that, unless you're there, you won't know. You get what I'm saying? Unless you're there, you won't know. You know. Shout out to the individuals who decided to share the information, like Mr. Dennis Byron. He shared that my information that I provided in regard to the juror who basically was arguing with the judge. Oh, hold on a second. I got a call from hold on. Just a second. I gotta just bear with me a second. I'm gonna play some waiting music because I just gotta return this one of my contacts just called me back. Hold on a second, okay? Just listen to some waiting music and I'll be right back. Okay, my bad. I apologize. I might be you know what? I should have showed y'all some footage. That's what I should have did instead of just having you guys just doing nothing. Well anyway, as I was saying, I'm going to give you guys some updates in regarding to what's happening in the courtroom. What's happening in the courtroom. As you guys know, there's been a lot of shenanigans, a lot of craziness in the courtroom, a lot of stuff, right? Um, well, I want to give you an update. It looks like two of the defendants is going to be severed. Two more defendants are going to be severed from the case. And you remember the two ladies that were with child, Miss Flanagan and Miss I forgot her the other one's name? Well, those two, if you notice in the video, if you guys watched the video that was shown yesterday, you notice how they were standing up talking to the judge right after the end. And the state is offering a severed, and I think they are going to accept it. So those two cases most likely is going to be severed, going to be taken off the case. Okay. So the judge is going to address that tomorrow morning at 10:30 a.m. Okay. Hey Randa. Hey Mika. Hey. Oh no, it was nothing. I just started talking, Randa. I just started talking because I was playing music for them because I had stepped away because I had to make a I might be getting another call. So if I get a call, I will let you guys know. So okay. So okay. So who cares? It might be. So who cares? Might be separate. Well, oh, whose case? I said, oh, you know what? My glasses need to be fixed because I thought you said who cares? Whose case? The two guys, Mender and what's the other one's name? Mender and the two with the pregnant ladies. The two that's pregnant. I know Mender is one of them, and the other one Flanagan, and the other one has like an African last name. Let me see. What's her name? Anybody remember what's her last name? Because she's not talked about not too much. Hold on, I'll tell you. Hold on, y'all. Wait a second. Hold on, just 1 second. It is. It is. Her name is Tumdri. Tumdri. Hold on a second. I got a call. Hold on. Hey, lady. Okay, I apologize, guys. I apologize again. Um, I was saying she's the what? They're sitting here. She's terrible. What am I terrible about? What am I saying? Oh, because I can't see too well. I need to get new glasses. Yeah, I need new glasses. My glasses like so fuzzy, and some things look like an S, look like a R, R look like an S. I don't know. Just bear with me a second, okay? I need to go to the doctor and get my eyes checked. But anyway, stop talking, Bobby, while I'm trying to do this commentary. The two attorneys, I did tell you her name, right? Did I tell you guys her name? The other one is Flanagan and Tomimbre Callaland. So it's Fallaghan, Nicole Fallaghan, and Tomumbre Callaland. Those are the two attorneys. Those are the ladies that are pregnant, and one is for Mender, and the other one is for what's the other client's name? Adams, Khalif Adams. So it's Khalif Adams' attorney, which is Callaland, and then the other one is and remember, these are the two defendants who are already serving time. These are the two defendants already serving time. So those are the two. So it's going to be down to 11 if the judge okays them to be severed. So, because remember, it's 13 now, and then the other guy going to end up being severed too. The one who looked off in space, Merrick. So it's going to be like down to 10 eventually. Because they still have to get his evaluation, and all of those guys, they all serving time. They all have have their own cases already. Had nothing to do with what's happening with. They were added on to this case, to this RICO. So, because remember, Khalif Adam was the one that that the main case was under for some strange reason. I don't know why, but then they made Doug the leader. Okay. So, the next thing, I did tell you guys that the attorney did turn in his paper. I spoke with him, and he said that he turned it in. In fact, the AJC is did an article on him, and I did reach out to the AJC person, and I am waiting for that article because they did do an article on him. Okay. Now, the next thing is the juror. The juror supposedly, and I know Dennis, y'all, I know he put it out, and I know people have been carrying the information. They were not there on Friday. Neither was I, but I had an individual who told me exactly what happened. And so all this third, fourth, fifth, sixth person information is it'll be validated on Wednesday when the judge have the jurors stuff coming up, and I'll tell you in details what actually happened and what date the judge is bringing her back for contentment. So most likely it's going to be Wednesday. Now the other thing, we're still waiting on the ruling from Judge Glanville on regarding to the motion they submitted for reconsideration for bond for Thug. And the reason why I was saying to you guys that Thug doesn't have a murder case on his person, on his filing, is because you guys know Farley is accused of a murder, and he just recently got bond, right? He just recently got bond. So this makes it a strong argument for Mr. Steele in regards to Doug getting bond. And I'm going to read the motion that he submitted for Doug's bond in a few minutes, but I just wanted to give you guys that information. That should be coming up as well. So tomorrow should be a very busy day with motions and things like that. And he did say that we're going to get a chance to do some jury hardship. Is Farley out? As far as I know, no, he is not. Because I did speak to Manassas yesterday. I spoke with him yesterday. Randa, I spoke to him yesterday. And because he was at court yesterday. They said they're working on it. That's what they said. They said they're working on it. They're working on it. They said he's working on it. Okay. So that is that on that. So all I'm going to do is show y'all some footage in between my talk with y'all. I'm going to read the motion. There's a lot of stuff I have not gotten a chance to read to you guys. I've had it for a while and I just haven't had a chance to get to this because I've been like running around back and forth and stuff like that. So there was something else I want to bring to you guys' attention in regarding to this case. I think this case is just running its toll on everybody. It's running its toll. It's a lot. Oh, I wanted to tell you guys there is a thing that came out, and I'm gonna give credit to the producers. I think it's AJC. No, it was Fox. Fox News put this out today. Was it today? No, last week sometime. And in regard to, now I'm telling you, some people are notorious for being snitches. Somebody snitched on one of the attorneys, y'all. Somebody snitched on her, and I'm going to show you what they put out. Hold on a second. It is like, wow, you guys just like snitching like this? Hold on a second. Just bear with me for a moment. Okay, hold on. They end up snitching on her. They even showed the message. I'm like, wow, these people just like no loyalty, no what is it? I don't know what the word is that you call when you have somebody who's going to be in the trenches with you and it's not going to tell on you, no solidarity among the lawyers. It's every man for himself. It's a doggy dog world out there. It's a doggy dog world. All right, hold on here. Hold on. Just 1 second. Okay, Ellen. You have so much stuff on your phones and stuff like that. I get so much information throughout the day, and it's like, oh. You know what? I'm going to play y'all some footage while I go ahead and search for this information for you guys. Just bear with me a second. I'm going to share some footage with you guys so y'all won't be that bored. All right, here we go.
How are you? Are you in the middle of doing something? Freshwater fish. It's freshwater fish. Fish man. Every Friday we had this year. I'm just telling you how many pieces of bread that's awesome. We said Blackberry. Get you some. Hold on one second. I'm just getting my computer.
You see the attorney up in the front right here? The one that's sitting? That's Flanagan. The one with the white top on? That's the one that's gonna be severed. But okay, this is what I wanted to show you guys. This news article. Okay, some Crushy, why are you deleting? Wait, hold on a second. Crushy shouldn't be. Randy, you got a wrench. Why are you somebody's deleting? Crushy 365. Why are you deleting Miranda's stuff? Hold on. Hold on. Let's see what's going on here. How is Crushy? Wait a minute. How is Crushy 365 able to delete anything from Miranda? Hold on a second. Let me go remove Crushy 365 wrench because you don't be removing my girl stuff. That's a no-no. Hold on. Hold on. Crushy 365 about to lose her wrench right now. Because you just deleting Miranda's stuff? Oh, no. We don't have that. Not my sis. You deleting my sis stuff? Oh, no. That's it. Hold on a second, y'all. Hello? Hey. Nothing. How are you? One second. Hold on. I am Okay, 365, you just lost your privileges. You was holding your phone in your hand. You deleting my girl. You can't be deleting Randa. You can't be deleting Randa. Oh no. That's the wrong person to delete. Certain people you cannot delete. I'm sorry. You cannot. You just lost your privileges. I was like, wait a minute. Why is my sis stuff is just being deleted? Hold on. Let me see who's doing that to her. And it was you, the culprit. Crush 365, the culprit. Delete my girl stuff. Man, she was deleting you left. He or she, Crush, you or he or she. And she was coming after Randa. Randa, dang. That's a no. Mm. I didn't see the second. Okay, let me go ahead and finish this one here, and then I'll do 13 came back in here to start trouble again. Jay, look who's here. 13 is here, Jay. Well, let me finish. They said they didn't mean to. Hey, Rachel. All right, let me go ahead and show you this article. Not article, this see what happened is Crushy had that super power of mod. So we're gonna downgrade you to the regular mod, not that super power one. The super power one can do all mods. Because they got new mod session. Yeah. So I'm gonna downgrade Crushy from that super mod. Crushy was just like, let me get this person. Let me get that person. Let me get that person. All right, we're gonna. You're a regular mod now, Crush. You can't get that super mod because you're making mistakes. We can't afford the mistakes on a super mod. Only certain people get the super mod. So you regular mod now. All right. Did you say? All right, Jake, you good. You good now, Jake. All right, let me go ahead on and show you guys this video here. And so we can continue our work. All right, let's see. This is Hey, Crushy, don't be yelling at me. I just gave you your mod thing back. Stop yelling at me. Don't yell at me. I gave it to you, Crushy. I know, you said it was a mistake. You got it back. There's two type of mod. There's super mod, there's regular mod. And Crushy was a super mod. But Crushy don't know how to handle super mod, so she's a regular mod now. Crushy yelling at me with those capital letters. Okay, yeah, let's go. Let's do this. Let's do this. All right, here we go. No, they didn't get in trouble for talking to Thug.
The path to business success is often unpredictable. Managing your bank account doesn't need to be. Find your flow with powerfully smooth banking that keeps you focused on bringing your vision to life.
Okay, here we go.
Angela DeWilliams last week filed a motion asking to withdraw from representing Rodelius Ryan in the YSL trial. DeWilliams says the pay is too low, only $15,000 for a case that could last a year.
This is not fair.
But the Georgia Public Defender Council accuses DeWilliams of saying one thing on camera and something very different in private. The GPDC filed a motion containing what it says is a text message from DeWilliams to her colleagues. It reads, quote, "I filed my motion to withdraw as a way to force GPDC to pay me more money. Please do not help the judge grant my motion. The goal is to have the judge deny my motion." The message also reads, quote, "If the press asks, please do not say you hope the judge grants my motion."
What's unusual is to file a motion that you don't want granted.
Tom Church is a criminal trial attorney.
Here, what we're seeing is an attorney filing a motion, ostensibly asking the judge to let them out of the case, while it appears or it's alleged is asking other attorneys, hey, don't support me. I want this motion to get denied. I'm trying to prove a point.
It's disappointing and it's unusual.
Daryl Cohen is a criminal defense lawyer and a former prosecutor in the Fulton County DA's office.
My view is it's not professional. Do I think it's unethical? For me, I would say yes.
The GPDC wants to remove DeWilliams from representing her client. Cohen says the lawyer could face discipline from the court.
And I think the worst thing that would happen would be a reprimand, and probably not even a public reprimand. It would be, hey, you know better. You shouldn't have done it. Don't do it again.
All right. Here we go. You heard that. Toya said, damn. Somebody gave the text message. You saw that, right? They gave her text messages. Oh my God. I tell you, cutthroat, y'all. Cutthroat. They are not playing with each other. Cutthroat. Cutthroat. Hey, Veracity Med Career. They cutthroat. You see that? They snitching on each other. They showed the text message that she sent them, and she gave it to the news. Lord have mercy. This is not good. Not good at all. It's pretty sad that, you can't even trust your colleague. They're just telling on you. But let me go ahead on and pull up the motion and read it to you guys, because I have not. There's so much stuff that I have not shown you guys in a while, and I'm trying to play catch up. I should have came on earlier to play this catch up, but Toya, you think so? I don't know who's the snitch. You said a GPDC employee who was in the chat. Who was that? The snitch is named in the motions? Oh, okay. Okay. All right, let me go ahead on and pull Doug's motion that I've had for you guys for a while. But let me go ahead and continue our footage until I put my trusty old watermark, because folks be snatching up my stuff, so I have to put my watermark on my stuff. All right, here we go. Hey, 13. Gina Bernard is another attorney. That's what's the name? Merrick attorney. You know that, right? That's Merrick's attorney. Yes, Dr. DTH. Yes, he turned on the paper. I talked about that earlier. I spoke with him and he said he turned it in, and that I'm going to read what the article says. Hold on. I'm going to read to y'all the article. Where is the article? Just bear with me a second. Just going to give you a snippet of the article. Okay, let's continue.
All right. Superior Court of Fulton County, Atlanta District, now session. Honorable Chief Judge, you are glad to have court now come order. Now, here, ladies and gentlemen.
I got the paperwork ready. Y'all ready for me to read the paperwork and continue with our footage in a minute? All right, I'm going to continue our footage in a minute after I read the paperwork. Let me just get this off of the screen here. And this is regarding Mr. Williams' motion for reconsideration for a bond. This is from Mr. Williams' bond hearing. All right, here we go. You guys can see this? Can you guys see this? Can you see this? Good. Looks good, right? Okay, let's go ahead on and read it. I'm going to have to go to the other side to read it for you guys. All right, here we go. State of Georgia versus Jeffrey Williams, defendant, indictment number 22SC183572, Judge Glanville, renewed motion for a bond. Now comes Mr. Jeffrey Williams by and through undersigned counsel, and hereby files this renewed motion for bond in the above referenced case. In support of this renewed motion for bond, Mr. Williams shows as follows. Number one, Mr. Williams is innocent of all charges in the above referenced case. Number two, since on or about May 9th, I'm just trying to see today's date. Okay, it's almost a year. Mr. Williams has been languishing the county jail without bond. Number three, Mr. Williams has previously put forth compelling evidence without doubt that conditions can be imposed which permit bonds to be set. This honorable court denied bond based upon proffers made by the prosecution, mostly repeating allegation contained in the indictment. Number four, undersigned counsel believed that conditions can be ensured that Mr. Williams comes back to court, which requires to do so, and due to the extent nature of this trial, Mr. Williams respectfully requests that the honorable court reconsider its position on bond. Since May 9th, 2022, Mr. Williams has only eaten nutritional food that includes carrot, rice, lettuce, bean, and hot dogs. The other foods that Mr. Williams has eaten has zero health benefit, consisting mostly of chocolate, M&M, chips, and other items that are processed and artificial. Okay. Okay. Number six, Mr. Williams is sleep deprived, mandated to wake up on court days, between 3 a.m. and 4 a.m. and not having more than 5 hours of sleep per night. By the end of the week, Mr. Williams is fighting to pay attention on the ongoing in this case. On the going ons in this case. Wow. Number seven, Mr. Williams has seen no sunlight since May 9th, 2022, and the only fresh air that he receives is during the time that the doors are open on the transport to and from the courthouse. Number eight, additionally, exercise is limited in the small jail cell. Number nine, with trial approaching, Mr. Williams qualifies for pretrial bond pursuant of Ayala versus State, the case number there, and thus respectively request that the Honorable Court to grant a reasonable bond. Wherefore, Mr. William respectfully asks his Honorable Court to hold a hearing on this motion, and at the conclusion of the same, ask the Honorable Court to grant the above request relief. Do you guys think this is a do you think this is a good motion? I'm going to show you the motion that was set forth for one of the YFN individuals who got bond, and I'm going to show you what they said in their requests. How about that? How about that? Hot dogs. Yeah, but let me show you what the people from the YFN Lucci. There's two individuals on that case. It's different strategy. Still already filled 60 pages on motion and got denied. This time he wanted to argue everything in person. Oh, okay, got you. All right. And not let the state respond. Okay, got you. Okay, 13. 13 must be an attorney. 13, who are you? Who are you, 13? Because he filled the other request for bond, I believe that he's just taking a different approach. Okay, Sierra. Yeah, if even been in jail, then you know the way. What in the world? Wait a minute. And Bobby, you already know I can't get my reading right. You could have say stuff like this, and I'm like, okay, is this Ebonic or what is going on here? I'm gonna try to read what you said here, Bobby. Okay, hold on a second. Y'all do not talk about me because I'm sound like I'm reading Ebonic, but this is how Bobby's writing it in here, okay? Yay, if ever been to jail, then you know they walk you up at 3 in the morning. They wake you up at 3 in the morning for court. Have you waiting in a little cell with 40 inmates for hours until court. Still certainly brings up Farley argument once he is in the podium. Yes, 13, I hope so. She have never put in writing 100% best of the best. I agree. I'll believe. Okay. Sylvia, cut it out. Don't worry about it. So, hey, look, I'm just saying, you already know me and my reading sucks. I get on myself. Angelique said, if the state opposes this bond, they are heartless. This case is just dragging. Let him go home. Y'all. Okay, Sylvia, that's country talk. You know how to talk down south. Bobby, I'm not trying to get on you, Bobby. I just was getting confused, okay? So don't think I'm coming at you. There's them people over here. Like Shanique was doing this. I'm not doing that, okay? There was something else I wanted to show you guys the other. So then there's no need for me to show you the other guys. Hey, Koopy, the other guy's motion. Do you want to see the other guy's motion or not? Let me know. Kelly say, yeah. Okay, Kelly, I'll go ahead. Sometime I don't think they should have them sitting in court all day. Duana, you know what? Let me tell you, I think it's a little bit better. You know why I say it's better? Because at least they get some sunshine, some sunlight, some sort of light. Because we need light. We need some sun in our body. People are saying there's a second motion for the judge to recruit himself. There is? I didn't see it. Is that true? I don't know. I haven't been in court today, so I don't know. Didn't hear anything about that. No, I haven't. Recruiter was denied. Yeah, that was for that act, not for the case. That was for the that hearing part in regards to the attorney and her money. That was that part. There's nothing wrong with country talk. Sylvia acting like she couldn't read it. You know I can't read anyway. Folks always tell me, Sylvia, you can't read. I'm like, okay, yeah, I can't. You're right. You're right. I can't read. But you're in my chat listening to me not reading Ebonic. Yeah, I saw Lil Rod's motion. Yeah, that's what it was in. Is it the exhibit 200 something? Is it in the exhibit 200 or something? I don't know. Country talk, country writing, different. That was Jay said that. Let me make sure people know who's saying this stuff. So, oh, guys, you got too much. We got a different set of crew in here. Guys, welcome to all my new folks from last night. Welcome to those individuals who has joined the infamous family. Guys, welcome. Those who don't know it, at 7 p.m. this evening, I will be transitioning to another topic, another case, a case with the man who was recently convicted for a case that happened back in 1999 with just a DNA of semen. And I know some of you probably go, what is she talking about? Well, it was a cold case. And so if you want to hear more about it, you could come on tonight at 7 p.m. when I do my live covering that case. Okay. Now, Duana says, in my opinion, I guess you meant opinion, you put in my option. Okay. I think it's going to be a mistrial, and so should be. 13 said, did you solve your beef with Law and Crime Network? Why are you bringing that up? 13, you a troublemaker. Why are you bringing that up? No, nothing's been solved. I just don't go over there. And if I do, I just stay in the bushes. I don't type because I already am blocked already. But shout out to Cheney. Cheney went in there. Cheney. He went in there. He saw it. I ain't see them blocking him. I think because he got powerful allies. So tomorrow, y'all. Hey, Getty, guess what? 13 is here, Getty. Getty, 13 is here. Did you solve your beef with Getty, 13? Since you're going to ask about trial and law and crime with me? Did you solve your beef with Getty? I knew Getty would get up. Getty came in right on time. Oh, 13, come on. You know 13 always fighting with you, Getty. 13 did jump out of here because my numbers went down from 77 to 75. You don't know who that person is? That person's always fighting with you. He used to be a he or she. I don't know if it's a she or he. Was in your chat for a while. He always fighting with you. Then he jumped over here with me. And then every time you got on my platform, he would say something nasty about you. But you came in, he or she jumped off. Oh. I didn't start, Mika. 13 started with me. 13 asked me, did I ever get my beef with law and crime resolved, right? So Getty jumped in. So I asked, did you ever get your beef resolved with Getty? It's not that important. Oh, Getty's being so serious right now. Well, anyway, y'all, don't forget tomorrow I'll be having an update. I'll be covering. I got my Rule 22 for Eva's divorce thing for tomorrow. So I'll be watching that tomorrow. I will bring you guys some 411 on that as well. Okay, let me go ahead and show some of the footage and get myself out of trouble. All right, let me show some footage. I'm lost. I don't know what that is, seriously. No, 13 is a person. 13 oblivious is a person. For some strange reason, 13 oblivious have some issues with you and you don't even know what the issue is. So, and that's why they jumped out of here. Eva Sterling, Eva, what is her name? The America's Top Model. America's Top Model. Not her, not Eva Marcellus. No. Eva, America. What's Eva's last name before she got married? She's Sterling now, but she was started with a P. Pickaninny? What was her name, y'all? The one that no one man should have that power. I guess you do, Getty. I guess you got that power. That you come into the room, they scatter. Oh, it's Marcel. Okay, I thought. Okay, Pigford. That's her middle name, but her last name is Pickford. Yeah, Pickford. Pigford. But her last name now is Sterling. I don't even know what it is either. No, that's not her last name. Her last name is Pigford. Pigford. Let me go look at the lady's name because y'all got it all mixed up here. Hold on. Pigford. She's right. It's Pigford. Yeah, she's right. Her middle name is Marcel. Current last name is Sterling because her husband name is Michael Sterling. Her last name is Pigford. Yeah, that's her name. Yep. Sorry about the autocorrect. Yeah, that's her name right there. There she go, right there. Well, she filed for divorce, and tomorrow I'll be covering that at 1 o'clock. They have her divorce hearing. Her husband's supposed to be answering to it, and it's a contest. He's contesting it, and so tomorrow is the hearing. You don't remember the person, Getty? You and the person used to go back and forth. They used to be on your channel. Don't you remember? Yeah, he's trying to get her back. Yep. So it is a contested divorce. Oh, he has? I was following them during the COVID thing. They seemed like they were just having a good time. Like they had a beautiful family, you know? So I guess you can't make assumption, huh? Getty said, "How you mad at me? I don't even know it." 13, are you hiding in the bushes? Wow. Are you hiding in the bushes, 13? Getty don't even know why you're mad. Getty don't even know, but you're upset. As soon as you came in, they pew. All right, let me go ahead and show this coverage here. And yeah, let's get going. Anybody have any questions before I start playing it again? Anybody have any questions in regard to the stuff I talked about? Because I know a couple of people who was not here when I started. I'm giving you guys some 411. So anybody have any questions in what I was speaking about? Oh, you wanted me to bring that one? Okay, I thought you didn't want me to bring that one up. Okay, I'll go ahead and get it because I've had it in my my little stash here, so I can go ahead and bring it up for you guys. Just bear with me a second as I bring up the bond. 1 second. Okay, here's Hawkins. Hawkins is the person. No, the footage wasn't over. You want the footage? No, it's not over yet. Let me just go ahead and show the bond thing here, and then I'll go ahead and do the footage. Okay, this is Hawkins' bond request, right? And his was approved. His was approved. Let me go ahead and but see, they can't use his because the situation in Cobb County is totally different than the one that's with Fulton. Fulton has the craziness that's going on. Okay, Here's the bond request that they have right here. You see it? It says here in the Supreme Court of Fulton County, state of Georgia, and then they have a case number and everything. Motion for bond. Now comes defendant in the above style action and respectively move this court to set a reasonable bond therein. Defendant, number one, defendant has been consistently incarcerated at the Fulton County Jail. Number two, the defendant poses no significant threat of fleeing from this jurisdiction, of failing to appear in court when required, of committing any felony pending trial, of intimidating witnesses, and otherwise obstruction the administration of justice. Number three, the sheriff of Fulton County Jail has admitted that he is unable to keep inmates safe, resulting in many deaths and serious physical injury to many inmates. Respectfully request the 4th day of November 2022. And it gives a date, Stacy Levy. So they got their bond approved, and I'm going to show you his bond approval. Thank you, Dom, for my Cash App. All right, so that's what she put in, and I'm going to show you his bond, what they gave him. This was Mr. Harkins. Let me give you what his bond amount was. Hold on. Let me get it for y'all. And this is his bond right here. Hold on. I gotta go give you the paperwork done. Hold on, I gotta go all the way up and get it for you. Hold on. Wrong person's bond. I was looking at Mr. Kelly's bond. Hold on a second. Trying to pull it up. All right, I'm gonna show you the video while I get the bond. Hold on a second, because it's on a different drive. Hold on a second. Let me just show you these videos while we get the bond together. Hold on. Okay, I got it. I have to stop it so I can show you his bond. His bond was less than and he got a murder charge. Hold on a second. No. This one didn't have a murder charge. He had a possession of a gun. Hold on a second. Let me show you his bond. Okay, you guys, y'all see this? Can you guys see that? This is Rodrelius, whatever, Ron Davius Harkins. And here's his charge. He has violation of the RICO, right? He has street gang, right? Violation of street gang again. He has a possession of a revolver, pistol by someone under the age of 18. First offense. Okay. His bond was granted right here, and it's for $400,000. Did you hear that? $400,000, and he is out. He is out. This guy did post it out because when I went on the because remember I went to the hearing and he was in the store shopping. I saw him in the store. I said, "Oh, this guy got a bond." Wow. Yeah, he was in the store shopping. Him and another guy. There's two of them that got bond. The other one, his bond was $55,000. I can go show you his. Let me go show you his. Yeah, his, but that's Follies. But let's go show you. Let me show you the other guy's bond so you guys can see. And they are a RICO case too. Remember, they're RICO. And they got a lot of murders on their case. But it's a different judge too. So we can't go by the same thing because it's a different judge. Each judge have their own way of coming up with the bond. Hold on a second. Let me go back. Let's go see. And remember, let's see. I think his name was Usri, something like that. The guy's name. No, Usri, he pleaded guilty. He got a plea deal. Let me go get the other guy, bond. Just 1 second. Okay, this is the other guy's. His name is Adam. This guy's name is Adam. Hold on, let me show you. This is the YFN, guys, and let me show you his charge. All right, this is Derek Adams, and he is in violation of RICO, right? Violation of gang terrorism. Then he has gang terrorism again. He got entering a car. He got theft by taken, felony, theft by taken, felony. And his bond was $55,000. $55,000 for his. And then here's his condition. It says if you change your current address, you must immediately notify in writing. The next one is failure to appear will result in a warrant being issued. You shall have no contact direct or indirectly with the victim's family, professional, personal, or so close associate by phone, email, mail, or through third party, including a victim's workplace, church, home, and daycare. If you encounter the victim, you must leave immediately and must not come within 200 yards of the victim. Then the additional condition is defendant cannot possess any firearms, drugs, or replica of weapons. The defendant cannot post on any social media site, nor text or contact any co-defendant or cross-defendants, including Joshua Capers, Wayne Alford, Tyrese Alford, Tiquisia Mender, Darius McLesser, and Marquise Brinkley. No further violation of the law. That the defendant is to be provided an ankle monitor paid by Fulton County. So that was his plea, his agreement. You know what? Let's go back and see the other guy's agreement. Hold on a second. Oh, Lucci did not. Let me tell you, he was on bond. They revoked his bond. I got that information as well. Hold on. Let me go pull that up for you guys. Hold on. Hold on. Just bear with me a second. Okay, this is Lucci's bond revoked. Okay, here's his bond revoke. They revoked his bond when he was out on bond. Let's go. Here we go. Here, it says here, his name is Rayshawn Bennett. State brief in support of the motion to revoke bond. Now comes the state of Georgia by and through the undersigned assistant district attorney and files this brief in support of the state's motion to revoke bond, respectively states as follows. Introduction. The defendant in the above style action was charged, arrested, and has been subsequently indicted in the above referenced case number with racketeering activity, murder, participation. Hold on. Okay, I'm sorry. Sorry. Participated in criminal street gang activity, aggravated assault, and possession of a firearm during the commission of a felony. The defendant's case is currently pending before the court. The defendant's action while on a previous issued bond shows that he is unwilling to abide by the special condition articulated in the bond order or any other, and further demonstrate that the defendant is a risk to reoffend and to a danger to community. Accordingly, the state hereby moves the court to revoke the defendant's bond. Procedural history. Primary incident giving rise to the charges that pertain to this defendant occurred on December 10th, 2020. Warrants for the defendant for multiple charges issued January 4th, 2021. The defendant rendered to the Fulton County Jail on January 13th, 2021. After extensive negotiation with the district attorney's office and multiple legal representative for the defendant, including Mr. Banks, Mr. Finding, and Mr. Dixon, the parties presented a consent bond to the presiding Superior Court judge, and it was entered on February 8th, 2021. The defendant was subsequently released from jail on the consent bond on February 8th, 2021. As a result of issuance with compliance with condition of the bond on multiple dates, the state moves to the revocation of the defendant's bond on April 12, 2021 on the basis of two positive drug screen. Another unauthorized studio visit. GPS ankle monitoring issue. Okay. And association with gang members. The case was indicted by Fulton County Grand Jury on April 30th, and at the time, the defendant was indicted for charges in addition to original warrant. Grand jury warrants for the new charges became active on May 4th, 2021, and defendant booked back into Fulton County Jail on May 10th, 2021. This court considered bond during a hearing on June 4th, 2021, and subsequently denied bond, but agreed to reopen the matter to consider evidence from the parties as to specific the specs. I'm sorry. Can't even talk. The specific of the issues surrounding the revocation request. A revocation bond continuation hearing was held on July 21st, 2021, and was continued as the result of an objection, the unavailability of the witness in person on that date. The court took up the reminder that the hearing in November 9th, 2021, and has requested a brief and proposed order from both parties. Specifically, this court requested that the parties to address the applicability of the evidence code during bond hearing, as well as the applicability of the 5th, 6th, and 14th Amendment. The court asked the parties to also consider if there is applicability, what the remedy is should there be a violation of those amendments. Finally, the court requested that the parties address if a district attorney's office can initiate the process of assessing compliance with the bond condition. Argument and citation of authority. Per OGC A24-1-2 C6, the rule of evidence except those with requests to privileges do not apply for proceeding with respect to release on bond. This decision seems to indicate that evidence rules generally do not apply to bond revocation hearings. You can see United States versus McKenzie, in the case number there, and it says federal rule of evidence does not apply in supervised release revocation hearing. Defendant involved in revocation proceeding are entitled to certain minimal due process requirements. Number 2, both the Georgia and the United States Constitution prohibits the state from depriving any person of life, liberty, or property without due process of law. United States Constitution Amendment number 14. It has been held that bond revocation hearings are subject to state and federal due process. Hood versus Costin. The United States Supreme Court has recognized that due process, unlike some legal rules, is not technically hold on. Okay, sorry. Where was I at? Number 2, was I at that? Evidence of release or revocation hearing, defendant involved in revocation process. Okay. Okay, we read that part already. Hold on. The United States Supreme Court has recognized that due process, unlike some legal rule, is not a technical conception with a fixed. Somebody just sent me something. With a fix unrelated to time, place, and circumstance. Matthew versus Eldridge. All right. Regardless whether the constitutional amendment is at issue applies to a bond revocation, here there are not any implicated by the facts of this case. The right against a self-incrimination is a trial right. A bond revocation is not a trial. Moreover, the defendant was not in custody and no right against self-incrimination was violated. The situation closest to someone on bond is someone on probation. The U.S. Supreme Court has held that questioning asked of a probationary by their probation officer do not violate the privilege against self-incrimination. Absent certain exception, the privilege against self-incrimination and not self-execution. Minnesota versus Murphy. Case law on that one. That is, one must assert it to enjoy its protection. None of the exception to the non-self-execution rule, even arguability, applies here. In Murphy, a probationary claims his right against his self-incrimination were violated when his probation officer asked him some questions. The Supreme Court disagreed and held that the probationary's rights were not violated since Murphy revealed incriminating information instead of timely asserting his Fifth Amendment privileges. His disclosure were not compelled incrimination, ID. Because he has not been compelled to incriminate himself, Murphy could not successfully invoke the privilege to prevent the information he volunteered to his probation officer from being used against him in a criminal prosecution. The state has not found any case which supports the defendant's claim as it pertains to the Sixth Amendment application or violation of this circumstance. Indeed, a defendant is not denied his right to counsel when the evidence show he was literally on the phone with his attorney. Further, communication between a defendant and attorney are only privileged to the extent they remain confidential. Roger versus State. Here, defendant openly spoke to an attorney on FaceTime while in the presence of a state actor. To establish a claim not cognizable under the Equal Protection Clause, a prisoner must demonstrate, one, that he was similarly situated with other prisoners who received more favorable treatment, and two, his discriminatory treatment was based on someone constitutionally protected interests, such as race, religion, national origin, poverty, or some other constitutional protected interest. Additionally, to succeed in an equal protection challenge, a party must demonstrate the existence of discriminatory intent. Arbitrary actions without discrimination intent is insufficient to demonstrate an equal protection violation. Jones versus White. The defendant has failed to establish that other prisoners or probationers are being treated more favorably. The defendant has failed to establish a constitutionally protected interest as such race, religion, national origin, poverty, or some other constitutionally protected interest in which he is a member of, and that the defendant has failed to demonstrate the existence of any discriminatory intent. The defendant has not been treated differently from others who agreed to the condition that he agreed to on February 8th, 2021 bond. The defendant is in a class of one. The sufficiency of the defendant's agreement is agreement to a particular set of conditions cannot be understood because they were negotiated with the benefit of multiple counsel and were outlined and articulated with a primarily and the enforcement and assessment of those agreed are now the basis for the defendant's assertion of a high scrutiny that raises to a violation of this right. Any state's actor assessment of the defendant's adherence to the conditions of pretrial release should not, and is this case did not violate the 5th, 6th, and 14th Amendment. There was no violation of any constitutional amendment, but instead an attempt by a DCS GBI agent to ensure the compliance with the Fulton County Superior Court bond and its special condition. All right, this is boring. Number 3. Finding for the violation of the 5th, 6th, or 14th Amendment would trigger a suppression of the resultant evidence. There has been no such violation in this matter. The order of the court from February 8, 2021 listed a series of special conditions agreed upon by the parties, including but not limited to no violation of the articulated curfew, no association with known gang members, no trip to studio, and random screening for drugs. Any questions of the defendant, any question of the defendant at any encounter that occurred with representation from the state agency, including the testified to March and April home visit, were limited to inquiries related to bond condition and the assessment of the same. Importantly, none of the exchanges in question has any impact, relations to, or bearing on any matter that related to even tangibility of the defendant's underlying criminal charges or the large investigation. The assessment of the defendant's compliance with bond is certainly not equivalent to custodial questioning about the underlying criminal charges or the related investigation. The reference exchange in this case resulted in adverse administrative action and the potential to be returned to custody on a bond revocation. Here, there has been no evidence of, and certainly there was not any investigation or questioning about this defendant's pending criminal case. The claims of 5th, 6th, and 4th Amendment violation are without merit and must fail. Number 4, there is no codified rule that pertains to limitations around an agency that may enforce bond condition. The American Bar Association articulates a preference for creation of pretrial services, and this jurisdiction adopts the same as outlined in our Uniform Superior Court Rules. Uniform Superior Court Rules 27.1, so 27.1, C, American Association Bar Standard 10.1. Nothing in the establishment of the pretrial services unit indicates that it is the exclusive mechanism for pretrial bond supervision or regulation. Fulton County Pretrial Release Program has levels of supervision, and the most rigorous form of pretrial release is classified as the Intense Supervision Program, or ISP. The minimum requirement of that level of supervision require meeting with case managers 3 times per week and may include additional conditions like electronic monitoring, curfew, securing a GED, and anger management counseling. ISP case managers work hours to accommodate visit throughout the week and into the evening to ensure compliance. The baseline condition of ISP supervision level through pretrial are significantly more intensive than the condition this defendant agreed to abide by. In the February 8th, 2021 bond order, no pretrial level of supervision is articulated, and the parties that negotiate that agreement, including the defendant, understood that representative from multiple agencies, including the Atlanta Police Department, Department of Community Supervision, and a representative from the District Attorney's Office may be involved in the bond condition. Agent Viviterio, employed by the Department of Community Supervision and assigned to the GBI task force, was at the residence to access bond compliance. Agent Viviterio was certified in the drug test panel being administered and was someone who has been previously included in the vetting of the residents that occur at the outset of bond. That agreement on vetting of the residents include an exchange of information for the future access to the home for compliance purpose would be possible. Conclusion. The parties enter into agreement that was subsequently adopted and accepted by the court on February 8th, 2021. The condition of the agreement were the result of negotiation, and the enforcement of those conditions does not give rise to any inequitable treatment under the law of the state or the Constitution of the United States. As the result of the violation of multiple special conditions of that bond, the state respectively requests that its motion for revocation, okay, I can't even say the word anymore. I said it so many times. Revocation of the defendant's bond be granted. Respectively submitted November 12, 2021. Carol M. Convery, the Assistant District Attorney. All right, so that was the reason why he got his bond taken away. He violated by going to the studio. He tested with drugs, and he failed the drug test. And he was not supposed to be with a gang member, and he was with a known gang member. So that's the reason why his bond was taken away from him. It was revoked. That was Lucci's bond revocation was taken away. His bond was revoked. Okay, short term revoked. So they took his bond away. He was on bond, and he was told not to do anything bad, and he did something bad. So now they took his bond away. So he's back in jail, no bond. Anybody got any question on that one? Did y'all fall asleep on my boring reading, my Ebonic self, non-reading button? Did y'all fall asleep on me? Well, so that's what happened with him. He got his bond taken away because he violated by doing 4 things that he wasn't supposed to. Angelique said he did it to himself. Honestly, yeah, I guess you're right, Angelique. Yes, you did it. I mean, he was out and he did all that stuff. You got all that stuff. And they tried to go for him to get a bond and deny it. They denied his bond. So, is there anything, or should I? It's almost my 2-hour time frame. You know me, I don't like to stay on here past 2 hours. Is there anything else I forgot? Is there anything else I forgot? I think they should be able to go to the studio. Let's see. Studio technique that his work, and he has been to go to work. Okay, but he had a curfew. He went to the studio late at night. He had a curfew. Remember? He could go to the studio when it's not late. He had a curfew. He had to be in by a certain time. When we'll still argue the bond again. Hopefully this week. Hopefully this week. Hopefully this week. I don't know when, but hopefully it'll be this week. He just. Oh yeah, you're right. You're right. It was. You know what? Let's go read his bond condition. No, we don't. I don't have it here. I was gonna say, well, let's go read his bond condition. We don't have it here. That was. I didn't go pull that. I'll pull it out and see what was his bond condition. Whether or not he could not go at all, or he could not go at a certain time. I know he could not be around gang members. So I'm thinking that there must have been some gang members there. That's the reason why. At the studio, I don't know. Oh, the judge said he'll give a schedule for everything tomorrow. Okay. Thank you, Angelique. Thank you for, because I wasn't paying attention to the info. You know how when you have a thing on video, I said I was just gonna watch the video and hear what he said. So that's what I was gonna do. So I'm gonna get off so I can give me a few minutes nap, because I'll be coming back on to continue my coverage of that case. All right, guys. I think that's it for the other violation. I understand they are grounds for revoked by the studio is his workplace. Yeah. Do he have a studio in his house? Just asking. I'm just asking. Okay, let me finish the rest of this this thing here, because I said I was gonna finish the footage. I'm gonna finish it off so you guys can see it. We got just about 17 more minutes left of this. Oh, the judge did take the mandate for the mask off, so they don't have to wear mask anymore if they don't want to. But
Cleve Adams et al. In 22 SC 183572. Good afternoon, Mr. Beebe and Mr. Partridge. Mr. Stillwell and Mr. Mr. Sharp, good afternoon. Mr. Williams and Mr. Steele, good afternoon, gentlemen. Mr. Mender and Ms. Fagan, good afternoon. Mr. Kendrick and Mr. Weinstein, good afternoon. All right, Mr. Huey and Mr. Matthews, good afternoon. Mr. Myrick and Ms. Bernard, good afternoon. Mr. Nichols and Mr. Garner, good afternoon. Mr. Adams and Ms. Callan, good afternoon. Mr. Blaylock and Mr. Hill, good afternoon. Mr. Dorsey and Mr. Jimenez, good afternoon. Mr. Eppinger, Mr. Johnson, good afternoon. And Mr. Ryan and Ms. D. Williams, good afternoon. Okay. Good afternoon, Mr. Floyd. I'm sorry. Good afternoon, Ms. Hilton. Good afternoon, Ms. Love. Good afternoon. And we should have Mr. Randolph, please. Is that correct?
Good afternoon, Your Honor.
All right, good. We have Ms. Kelly. She's
No, Your Honor.
So she's still on. Must deserve a rest. Okay, all right. Okay, all right, first things first. Councils, Mr. Steele and Mr. Floyd, I've had an opportunity to sleep on the issues presented yesterday in regards to the plea and bar joint motion to strike all predicate acts from count one. They've already been adjudicated by a court of competent jurisdiction. And after thinking and also studying the law relative to this case, Mr. Steele, you made a pretty novel argument, but I'm not going to follow at this point in time. So I'm going to deny your motion. Mr. Floyd, if you would prepare a suitable order and submit that to Mr. Steele for his perusal, as well as the other lawyers. And I'd like you to distinguish in that order that those particular individuals who have remain on this, they're on this indictment who have prior convictions or are severed would have in fact standing, and I do find they do have standing to raise that motion. I am in agreement that those who have pled, waiver applies. And for those who are, and the third category is those people that that don't fall into category 1 or 2 would not have standing. Despite Mr. Steele's very elegant argument to apply privies and and also the other concepts he asked me to apply. Okay.
Yes.
Yes, Mr. Short.
For the record, Mr. Stillwell jointly filed that motion, and I am under the belief that you are denying that, not just for Mr. Williams' assertion, but also for Mr. Stillwell's and for all of the other defendants.
You didn't listen to what I said, sir.
I did. I just want to make it clear for the record.
Well, then what are you trying to clear if I made it clear as to those three categories? If your client has a prior conviction, then he would be subject to category 1. Those particular people that have a particular prior incident that was an overt act, that are either on this indictment or have been severed, they would have standing. So I'll let you take a look at the order, and you can invite me to either change it or whatever, so that a draft will go out to begin with.
Oh, it wasn't a standing issue. It was just that we asserted the same argument that Mr. Williams.
I understand that.
Yes, thank you.
I understand that, but there's three categories of people that this argument falls under. I know Mr. Steele made that on behalf of everyone and tried to assert that everyone would have this particular type of right, but I'm distinguishing that those particular people that have prior convictions for arrest would in fact have standing, but that the people that, if they're on the indictment or they've been severed and they fall in that category, yes, I agree they would have standing. Those who have pled, waiver applies to them. And for those who do not have that, they would not be able to assert standing. At least that's what I'm gonna put in the order, have the order drafted to reflect that. Okay. Anything further, sir? You was asking for clarification?
We I understand. I'll ask for a few pages of the transcript just to make sure.
That would be fine, sir. And in fact, it's the 21st today. Do you believe you could have me something? I would say by the 19th of May. Would that give you enough time?
Yes, Your Honor, that will. Thank you.
Okay. All right.
Your Honor.
Yes.
Rudy Chada Jimenez on behalf of Mr. Dorsey. I understand the ruling. Just respectfully, I'd like to put 2 quick points on the record of just some points I wanted to make in response to Mr. Floyd's argument. The first point regarding to whether or not there's privity between us, I do believe the state made the argument, and I'm sorry, this is kind of loud. It's just, I hope it's not bothering people. That by us saying we're not associated, we're not part of the conspiracy, we have said that we don't have privity. And I just like to respectfully say that somebody can just choose whether or not they're previous. It is it is fact intensive as to if it was in a civil case, I couldn't just say, oh no, I chose not to be part of this. Collateral estoppel would still apply if the court was to determine that those claims should have been brought together. That's the first point. On the other point where Mr. Floyd said, well, you know what, if we were forced to use RICO at the time of the incidents when we knew about it, it would lead to premature prosecutions. It would lead to things where the state would be forced to go forward on something that they might not have fully developed. And my argument on that, Your Honor, just wanted to, again, just for the record, I understand you've ruled. My point is that, yes, I do believe that is the policy of RICO. My understanding of the way RICO works, it is a tool given to the state that is very broad and very malleable. And the point of that is to be able to capture conduct that is elusive in nature, that sometimes it might not seem to be criminal in nature. It might seem to be regular acts as a regular course of business that an enterprise enters into on a daily basis. However, if they do have the evidence to go forward on a criminal act, they can choose at the time, we will use this criminal act as an overt act as one of the predicate offenses, or we would prosecute it on its own. And if there's not enough, they can use RICO in the future and just be patient and hold on. But when they chose to go forward on this particular overt acts that they have already prosecuted, and people have faced consequences either after a trial or by negotiation, by a plea, by accepting a plea bargain, they have already faced consequences for the actions they have taken. So at that point, not arguing it is double jeopardy. We're not dealing with the concept of evidence being used up. That is not what we do anymore. We have taken the new test. You don't use up evidence. If there is a different element to the offense, yes, it's not double jeopardy. RICO and the underlying charges can still be prosecuted at the same time. Again, I am joining in the argument of Mr. Steele. It is not double jeopardy. It is collateral estoppel. They should have done RICO if they wanted to with Mr. Stillwell as an example, with any of the other young men that have been prosecuted and convicted and pled guilty already, or been have already faced consequences. They could have done it then, and they chose not to. And the reason they chose not to is because they, in their view, they had a solid case. So just wanted to put that on the record, and I joined in with Mr. Steele. Thank you.
I don't know if the court wishes to respond.
Yeah, sure, you can respond.
Just briefly, Your Honor, case I did not mention yesterday, State v. Loza, 426 Pacific 3rd, 34. This is at pages 41 and 42.
No, this is not
It's
from
a
yesterday. This is
unanimous
from, hold on,
Supreme Court
y'all.
Mexico case. Loza went through in essence
Hold on.
all issues.
Listen, guys, this is not from yesterday. This is from the 21st. You guys are yesterday. If you want to see yesterday, I could play yesterday's. This is from the 21st because I'm playing the stuff that was not played on Law and Crime channel. You know, those things. So that's what I'm playing. Now, if you want yesterday's, I can play it. I got it right here. This is like, because, I haven't shown anything in a while. And I was just showing you guys some stuff that I hadn't shown. So you guys let me know. I'm just showing you. Because I remember Mr. Steele had spoke about the motion he had filed for the what do you call it? Plea in chief. I forgot the name of it. But that's what I was going to give you the results of that. Because a couple of people was asking me the result. Did he rule on that, and the judge denied him on that rule. So, and there was some clarification that needed on that one. So, do you guys want yesterday's? I can play yesterday's for you if you want it. Let me know. I got all of it. I just don't play as much anymore because, the that channel's already showing it, and I didn't want to reproduce it. Oh my God. 13 came back as if Yeti was gone. Lord have mercy. Keep playing it? Okay. It's almost over. We got about 7 more minutes of this.
We discussed, but it particularly addressed this question of prematurely forcing the state to elect. It said it would be contrary to common sense and would undermine the purpose of racketeering legislation to force the state to choose between prosecuting the predicate offenses or pursuing a racketeering case. It talks about the structure, explains why that is the case, and cites also federal authority, saying a contrary interpretation would put federal prosecutors in the untenable position of having to choose between prosecuting either the predicate offenses or the RICO charge. Walks through exactly that argument and rejects it, as has every other court that I'm aware of.
Okay,
Thank you, sir.
thank you. Yes, Mr. Hill.
Very briefly on what happened. I mean, very briefly.
And just
one very quick point to, I guess, distinguish from Mr. Floyd's argument yesterday on behalf of Mr. Blaylock. I'm sorry, Justin Hill on behalf of Mr. Blaylock, by the way. Yesterday, if I'm not mistaken, if I understand Mr. Floyd's argument correctly, he mentioned when he was referencing the overt acts and trying to, I guess, distinguish that they were not the same conduct. If I'm not mistaken, he mentioned, I use this as an example, he mentioned maybe an overt act alleged from Mr. Blaylock. He also mentioned maybe an overt act alleged by Mr. Beebe to, I guess.
Which overt act is your client charged in? Let's focus on your client.
He's alleged of 79 through 81. I was using that as an example.
Okay, but let's focus on yours, okay?
Okay, I
All right,
guess
79 through 81, all right? Okay.
when it comes to Mr. Blaylock, his particular overt acts they literally stem from the same conduct. If you look at what is alleged to have happened, it is one singular incident, one singular piece of conduct that happens to have resulted in 3 alleged crimes. And I'll use this as an example. Let's say, for an example, there are 3 people standing in this corner, and I do the one single act of firing a firearm, and 3 people get hit. That is one conduct that results in 3 crimes. Now, then that is, if someone is killed, that would be murder, and if someone is shot, that would be aggravated assault. But that is still the same conduct, and that same conduct is what Mr. Blaylock is alleged as. That same conduct are the basis of Mr. Blaylock's overt acts in this particular case. And on that particular grounds is where I would like to distinguish Mr. Blaylock from some of the other people. In this particular matter, I still, not Mr. Steele's argument, but just with that particular situation, I would like to distinguish Mr. Blaylock and urge the court to consider that. Even in consideration of Bethune v. State, I know Mr. Steele, I mentioned this on Monday, and Mr. Steele mentioned this yesterday as well. But the court, the state, correctly conceded that the RICO prosecution could not be based on the 3 predicate acts that had already been convicted, that he had already been convicted of. And like I said, these particular acts are the same conduct that Mr. Blaylock has already been tried and wrongfully convicted of.
Okay, all right. Mr. Floyd?
30 seconds, Your Honor. That reference to the concession, as I pointed out yesterday, that was based on the then controlling case of Martin v. State. That's what was cited. We've discussed how Martin is no longer good law.
Martin's no longer
I won't
good
go
law.
through that again. The 3 predicate acts that were just referenced, the 3 acts were just referenced by Mr. Gill. He says it's the same conduct. There's 3 different victims. Murder victim is Jamari Holmes. Bernard Mitchell is a victim of aggravated assault. Rodney Uden is a victim of aggravated assault. Those offenses wouldn't even merge each other, much less convict.
Okay. All right, unless there's anything else, then let's turn and talk about joint strikes. Have you all had an opportunity to gather Ms. Hilton and Ms. Love with the defense?
We have, Your Honor.
Okay, and which people from Group 5 are you jointly asking this court to excuse for cause?
There is only one, Your Honor.
Only one, okay?
And that person is not a resident. It was juror number 1002.
1002.
Yeah.
Okay, hold on. Any councils disagree? 1002, would you like me to excuse 1002 for a cause? Okay, thank you, Mr. Matthews. All right. That was the only one, madam?
Yes, Your Honor.
Okay, all right. Okay, all right, councils. Then at this point, I believe that we are almost complete for today. And I want to say that, let me just review the next week's schedule. I have Dr. Dunbar on Monday starting at 10. Tuesday, the 25th, I have Mr. Persinger from 1 to about 5. On the 26th, we have Dr. Nelson starting at 10. On the 27th, we have Dr. Kubrin.
All right, guys. That was it on that one. Let me boot that one out. Boo, 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 boo. All right, we got that one out. Let's start the next one. Let's see what we got for the next one. Let's see what we got. Okay, yesterday. Y'all want yesterday's, right? Yes or no? Do you want yesterday's? I'm waiting for an answer. Okay, we'll do yesterday's because nobody's answering me yet, but we'll do yesterday's. I don't know what they stream and what they didn't stream because I didn't watch them yesterday, so I don't know. I don't know what they stream and what they didn't stream. They's little rod stuff. You mean to tell me when they were sitting down talking about the hold on, let me stop it for a second because you can't hear me. Hold on a second. You said but little rod stuff, you mean when they were talking to the attorney? When that lady was talking to the attorney, that part? I thought they showed it. Yeah, that's all they did yesterday. They didn't do anything else. I could bring it all the way to the end. Let's see what the end showed. Hold on. Hold on. Let's see what the end showed. They should have showed this.
2021 interview a month ago.
I think we had this discussion before, and that's probably part of, you still have several, Brady and and some motions in limine outstanding, so I haven't scheduled those yet, but I was hoping that what we could do is that around the time that we also set the six physical inspection days or physical evidence inspection days, and we also set some dates for you all to gather to make sure you have all your discovery. And then I can also counter those particular motions. I think we've heard the same issue a couple of times. I mean, I know it's the continual obligation to supplement versus what have I gotten. So maybe the best thing to do is to kind of just take a look at what you don't have, and then I can probably weigh in from there. Because I don't think anybody's trying to not give you anything that may be considered exculpatory or trying to hold back anything that they're not required to give you.
I am not accusing this.
I know you're not, but
I just want it to be ready, because at some point you're going to say, here goes individual voir dire, here's your jury, and however you're going to do it, let people get their affairs in order for a week or two, and you're on trial, and I don't want to be getting discovery at that point.
Yeah, I agree.
Okay. Thank you.
Yes. Okay, all right, anything else? Okay, all right. Unless we have anything else, then councils, I will see you all Wednesday at 10:00 hours for anticipated 10:30 start time, okay?
Yes.
Ms. Love?
You see how those two ladies going up to the judge right there? You see? This is what I was talking about. This is what I was talking about when I said that they, after the thing was over with, they started talking to the judge about severing their case. That's what I was talking about with you guys. Okay. But that was it, nothing else. All right, so I think I'm gonna play the Lil Rod thing. Lil Rod from let's see, I'm gonna play that one. What about the case? What case? What case, Emily? Emilia. Sorry, Emilia. I'm calling Emily. What case? What case are you referring to? Yeah, that was yesterday's.
and have lunch, and I'll see everybody back at,
My throat is itching.
our, we're bound by whatever answers you give us. I mean, and we'll be 1 to 3:30.
All right, y'all. So I think that's it for today. I'm gonna get myself ready for this tonight. And let me guys know what y'all wanna do. So tomorrow I will be sharing with you guys what I heard from the divorce situation with Eva, and then after that, that's it. But tonight I'm gonna go back to doing the other case with Corey McCarney. Okay. I'll check you guys later. Bye.